listen-only mode.
Hello, everybody. Good afternoon. Thank you for joining the webinar. My name is Milan Pajic, and I will be the moderator today. So I'm the policy advisor at the Foreign Trade Association, and I also keenly follow the developments which we'll be discussing today. But before we get into the introduction, please allow me to give you a few webinar logistics. So as you will be able to see soon on the next slide, it is important to know that everyone is muted, including the panelists and the audience. Questions will be at the end of the webinar, so after the panelists give their opening remarks. And during the question and answer, if you wish to ask a question, please do it so in the chat window. We will be collecting the answers, questions, and then giving it to the panelists for the answers. Also, regarding the audio check, please type in the chat if you cannot hear us so that our technical team can help you out. So if you have any problems with the streaming, please tell us so immediately. That will be all for the logistics. So as you can see here, this is my profile, so you can at least know who is speaking. And I will briefly now present the agenda from the next slide. So first I'm going to give a brief introduction about the Foreign Trade Association. Then Dr. Margaret Wachenfeld will give us the updates on responsible business conduct due diligence. Second, we have Mr. Gilles Gothard, who will give an introduction to the child labor due diligence law from the Netherlands. And our final speaker will be FTA's own Sylvie Tonnerre, who will talk about the French duty of care law for parent and subcontracting companies. And then we will go into the question and answer session. So, but before we enter the discussions, please allow me to present to you our organization. Since we have a record attendance today of 180 registered participants, we already have around 100 in the audience. And some of you might not be familiar with the FTA or our work. So it would be really good if we first explain a bit what we do and who we are. The Foreign Trade Association is the leading business association of international commerce that promotes the values of free and sustainable trade. This year, we will be celebrating our 40th anniversary on the 14th and 15th June in Brussels. But for more information, we'll be providing a link at the end of the webinar. And I would also like to use this opportunity to invite you all to our breakout session on the 15th of June, which is open to FTA members and the public, where we'll be continuing discussion from today's webinar, because today this is a very important topic, and we can see by this huge interest in our in the participants. FTA, although is not an exclusive European association, even though we have been based in Germany and Brussels over our 40-year history, we now have members from 37 countries around the world, and we have 5 offices, one in Hong Kong, Bangladesh, Turkey, India, and the USA. Regarding our membership, it has been growing remarkably, and we had a recent spike, and we now number over 1,900 retailers, importers, brands, and national associations. Our combined turnover is 1 trillion euros, which means that if we were a country, our economy would be the size of Australia's. So we do have quite a significant economic impact around the world. FTA is a clear market leader in the trade and sustainability sphere also, and we cooperate closely with many international bodies like the World Trade Organization, the International Labour Organization, and the European Union. Our 2 main aims are first to improve the practical, political, and legal frameworks for trade by providing members with a voice in trade discussions and access to exclusive policy updates on trade issues. The second is to promote sustainable supply chains by providing members with supply chain risk management, monitoring tools, and worldwide auditing services. Our booming membership shows that there is a clear need for companies to get engaged in open and sustainable trade activities, and they need to respond to the increasing expectations of all stakeholders that companies must assume their responsibilities towards society and the environment. To meet the sustainability needs of companies, we have founded in 2003 the BSCI, which is the Business Social Compliance Initiative, which many of you might be even more familiar than our parent association name. BSCI is the leading business initiative for companies to improve working conditions in their global supply chains. In a nutshell, BSCI helps members to conduct due diligence by, number one, monitoring the supply chain, providing support on remediation when needed, and thirdly, providing guidance and training on sustainability and CSR issues. So a perfect example of this is our module on the UK Modern Slavery Act from 2015. The BSCI system and the respective tools are helping FTA members in their due diligence process and the reporting exercise required by the UK legislation. So this means that we are closely following all the developments which our speakers will refer to today, and to ensure that our members are kept up to date with the legislative developments around Europe and globally, for example in the US and Australia. And we'll be preparing other modules to help guide them to excel in the process. So finally, I would just like to also say that with the remarkable success of BSCI that we have had, we have also launched our second sustainability program in 2014, which is the Business Environmental Performance Initiative. And as you can hear from the name, it addresses environmental and energy-related challenges in the supply chain. BEPI itself provides a system that supports companies to continue to improve environmental performance in their supply chain and through practical support. So if you have any questions regarding our services, we will provide you with the contact details at the end of the webinar. So as you can see also here, to give a face to all the things that I've just said. I'm sure it was a bit heavy on the first place, but if you go to our website, you will be able to see more and read more about our services and our team. Thank you. Now, this was the introduction, so let's get straight into the topic of today's webinar, which I think is highly interesting because we have such a great expertise around the table, on the line. And first I will give the floor to Dr. Margaret Wachenfeld to provide us with a brief overview of due diligence legislation in Europe. And she has really true great expertise on this issue, so I'm really keen to hear what she has to say.
Okay, thank you, Milan, and thanks very much for the invitation. Good morning, good afternoon to everybody. I was asked to give a very quick overview of what due diligence is and the international standards, just to situate everyone, because I understand there's a range of different people on the webinar today. So I'm going to do that. If you can go to the first slide, that will help. I guess we'll get that up. So, well, yes, that one, exactly. So just very quickly, because I think terminology in this area is very important. Due diligence is a long-standing practice of carrying out investigations for commercial transactions, whether it's been looking at legal risks or financial risks or exchange rate risks. Has actually transformed that term of due diligence, and it's really important to understand the difference when we're talking about responsible business conduct due diligence. Rather than looking at risks to the company, which is what you do in standard due diligence, you're looking at risks and impacts created by the company and its business relationships. So, although those two kinds of risks are increasingly interrelated, but that's a whole nother topic for another webinar on materiality. But this issue of responsible business conduct due diligence is outward looking. For those of you on the line from the environmental area, you'll of course recognize that this trend is this is an old trend, and it started a long time ago in the environmental area with tools like environmental and social impact assessments that look outwards. But we're now taking those tools and applying them to a whole range of different issues, including human rights in particular. I think the other key issue to understand about the terminology is that, again, commercial due diligence is often focused in particular on the step of identifying risk. But when we use the term for responsible business conduct, we're actually talking about the whole issue of managing the risk. So a management system approach, and again, those in the environmental area will understand this. But even for those in the environmental area, the new thing on responsible business conduct due diligence is going beyond and actually accounting for how those risks have been impacted, have been addressed, and doing that with your stakeholders. So the key point here, just very quickly, is that it's easy to find people using the same term due diligence and meaning different things. So if you're in the sustainability department and you're talking to your legal department about it, very good idea to ask your colleagues what they mean by due diligence so you're on the same page. Okay, next slide. So where has this new and transformed version of responsible business conduct due diligence been captured in international standards? It started very much with the UN guiding principles, with the idea that companies should use the process of due diligence to know and show that the company is respecting human rights. And the idea is that identifying, preventing, and mitigating adverse impacts on human rights and accounting for how they do it. So that's the full scope of the concept. And that they do that on a very systematic basis so that the due diligence processes of identifying, preventing, mitigating get woven into the way business is done on a daily basis. So again, I come back to this issue of being clear about what the terms mean, because you can see that it's important to understanding how this process should run. The other, and the key issue here is that the same concept has been incorporated not only into the guiding principles, but also into subsequent international standards. The 2011 revision of the OECD guidelines for multinational enterprises to ISO 26000, to the very new revised ILO declaration on multinational enterprises. And that's very important because it means that these terminology, approaches, and concepts among these different international standards were very purposely designed to be aligned around the same concept. And the other point of this is that these then standards are also being used to incorporate it into industry standards. They're being incorporated into contracts. That's a whole nother webinar. What I was asked to quickly address is how these issues are being incorporated into the legal legislative framework. So if we go to the next slide, I'll quickly move on to that issue. So just, again, having done a little bit of situating of the audience, in the next 5 minutes, I'm going to run through developments on this area. The most significant development in this area on the legislative side is the new French law, and the colleague is going to be speaking about that, so I'm not going to address that. Also to know that there's an initiative in Switzerland that is in front of the Swiss government to amend the Swiss constitution and adopt these requirements on Swiss companies. That has been presented to the Swiss government. It's currently under consideration. A number of EU parliaments, 8 national parliaments, presented to the European Commission what's called the Green Card Initiative, calling for mandatory due diligence at the EU level. The Commission has signaled that it will not be adopting mandatory due diligence, but interesting to see that trend coming. So that's looking at kind of very quickly at what's coming up on the legislative agenda for cross-cutting general requirements on RBC due diligence. But there are other trends if we go to the next slide. And that is that there are topic-specific legislation addressing severe human rights abuses. Milan already has referred to the UK Modern Slavery Act, which is more of a reporting directive, and again, we could get into that on the discussion, but you also have already had other requirements in the US, in California, the Transparency in Supply Chain Act, you have public procurement requirements in the U.S. that were adopted under the Obama administration. It will be interesting to see what happens to those under the current Trump administration. Gilles is going to, our Dutch colleague, is going to talk about draft legislation in the Netherlands on child labor. There is also, again, legislation in this area of looking at severe human rights abuses. Conflict minerals clearly falls into this space because it is very clearly associated and was adopted specifically for the purpose of trying to address human rights issues in conflict mineral supply chains. It's ironic that just at the time that the EU has finally adopted its conflict minerals regulation, that the US is potentially pedaling back on its conflict mineral legislation. And I think finally, in addition, it is worth reminding people that there are other, although this seems like a new topic, there are many existing requirements out there in law, whether it's labor law legislation, whether it's on discrimination. I mean, for example, our French colleague might talk about requirements under the French Civil Social Security and Labor Code that already requires French companies to verify that their subcontractors that they contract with comply with various French Social Security regulations. So that is already a form of due diligence that's built into law. And so although it may seem there's a lot of new issues, some of these are very much building on what's existing in law already. I'm going to very quickly get to a few other drivers for a focus on human rights due diligence. If you go to the next slide. What else is driving companies starting to build these systems for due diligence, for identifying, preventing, mitigating, and accounting for adverse human rights and other environmental consumer protection impacts both within the company and their supply chain? Well, another driver is that companies are increasingly being required to report on these. The EU Non-Financial Reporting Directive has come into force. National legislation should have been transposed already in December 2016. Companies to whom this directive applies are required to report in 2017 on what they are doing on environmental and social and human rights and labor rights issues. And if the board of directors has to sign off on this reporting, then presumably, again, companies are having to put in place the systematic approach of gathering this information so that they can report accurately. I think one of the other issues, besides the kind of pull from reporting, is the push from investors. Investors in Europe in particular are increasingly have a whole range of different requirements around what are called ESG issues, environmental, social, governance, corporate governance issues. And if investors are required to report on what they're doing to address these issues with companies, they are then asking the companies they're investing in to also themselves be reporting on these issues and adopting these systems. So I think you're very much seeing a push and a pull. If I can go to the next slide. In addition to these legislative drive for companies on reporting, there's also an increasing kind of offtake demand for this reporting information from different benchmarking initiatives. And now, very quickly, I think, Milan, if you can slowly click through the next slides, and I think these will be made available. What the next slides show is what some of the organizations, OECD, ISO, and ILO, are doing to increasingly adopt guidance. Now, this is not legislatively binding guidance, but it is guidance to help companies comply with requirements, both whether it's international standard requirements, which are not specifically legally binding, or upcoming legislative requirements. And I think the key point for this, the issue is these different organizations and the companies and stakeholders that participate in them are recognizing that there is a need for more guidance. There is a need to hone in on what does due diligence mean in a particular context? How far down the supply chain should it go? What other types of business relationships besides supply chain should be covered in due diligence? I mean, interestingly enough, the UN Guiding Principles on Business and Human Rights, which was at the start of this whole discussion, has a set of effectiveness criteria around what non-judicial grievance mechanisms should look at, but they never adopted and didn't incorporate what effectiveness criteria for due diligence. And I think what a lot of this sectoral guidance is trying to get to is defining what is effective due diligence. And the other key point on that is many of these organizations are doing it in a multi-stakeholder way. Effective due diligence and what that means is not going to be defined specifically only by governments or only by companies. It is about people, and so taking a multi-stakeholder approach to getting to that answer is very important. And I think the final slide, just one back, was that this issue, again, even though it's not quite legislative, but it's a sign that it's getting the focus in different high-level political forums, G7, G20, EU Council conclusions. There were 2 sets last year during the Dutch presidency that our next colleague Gilles was very much involved in and could answer questions about, but that's a clear signal about the political attention to this issue. And I recognize that was a huge amount of information to sweep through in a short amount of time, but if you then go to the next slide, a very good place to keep up on these developments is at the Business and Human Rights Resource Center. So I'm going to finish there, I hope more or less in time, and happy to answer any questions. Thank you.
Thank you, Margaret. This was a really great introduction, very exhaustive, very detailed, and very to the point. I'm sure that it's going to also make people more interested and to do more research also themselves to look into the issues that you have spoken about. So now we will switch to Mr. Gilles Goedhart, the Senior Policy Officer for Business and Human Rights at the Ministry of Foreign Affairs of the Kingdom of the Netherlands. As you know, the Netherlands has been a keen supporter of due diligence initiatives, especially during its presidency of the European Union last year. And it has been pushing for action at the EU level. So Mr. Goedhart will provide some insights on the status of the Dutch child labor due diligence law. Mr. Goedhart, the floor is yours.
Yes, thank you very much, Milan, and thank you for inviting me to speak on this topic. I'd be happy to answer any questions on related topics that were mentioned on the EU presidency, etc. as well later on. But for now, I'll be talking a bit about the child labor due diligence law, or rather bill, that was initiated last year. Next slide, please. It was initiated in 2016 by a member of the Dutch Labour Party. Actually, there was already previously quite a long process that led to this bill. Basically, the Member of Parliament had floated some ideas about this earlier, and it had been debated in Parliament. He'd been consulting with many different parties leading up to the initiation and the introduction of this bill last year. It was then debated in Parliament and voted on and adopted on the 7th of February this year in the House of Representatives. It then moved on to the Senate and is pending examination in the Senate. If approved, and that might be still this year, then the law will enter into force in 2020. So let me just go through the content of the law quickly. The law, or the bill, introduces some requirements for companies to give shape to this mandatory due diligence. It requires the companies covered to assess their value chains. So to do some, proper research into their business relationships. Then if risks of child labor emerge from that assessment, the companies should develop and implement an action plan to mitigate, to address these risks. And the company should also submit a statement of due diligence to the monitoring body, which basically outlines what they have done to assess and mitigate risks. Then the sanctions that are in place by the bill, if companies do not, for example, an NGO or somebody who has been harmed by a company's actions, then the company in question has 6 months to deal with the complaint together with the complainant. And if that is not done to the satisfaction of the complainant, then the monitoring body will start looking into it. We'll check to see whether it's properly assessed its value chains, whether it's developed and implemented the action plan. And if not, then it can either give a binding instruction to the company on what it should do, or it could do both. It could give an administrative fine to the company. Then there is another step if things escalate, as it were. If the same company again doesn't comply within a period of 5 years' time, then there is the possibility to prosecute the manager or managers that are responsible in a criminal procedure. Then if we could go to the next slide. There are some open questions related to the law that haven't been completely filled in yet. They've been left open in the bill. I won't go into a Dutch constitutional law, but basically the government is mandated to specify a couple of elements of the bill in separate regulations. And these are, the most significant one is the scope of application of the law. So it's not clear yet which companies or categories of companies would be covered or would be exempted from the law. It's clear in the bill that in principle, the bill would apply to companies that operate in the Netherlands, so not only Dutch companies, but companies that have, that have certain business in the Netherlands. But it's still possible for the government, after the law is adopted, to exempt certain companies. For example, the smallest companies. That would probably be the most likely outcome. Another thing is that the monitoring body that would have to monitor the law has not been determined yet. And the law leaves open, or the bill leaves open, a possibility for the government to regulate certain requirements for the value chain assessment that companies would have to do, for the action plan they would have to adopt, and for the statement that they would have to submit on their due diligence. So these are obviously pretty complicated issues, as it's not that clear cut. How far a company should go in doing this value chain and assessment, and what would be, that was it from my end. I think I went through it pretty quickly, but I'd be happy to answer any questions that are more specific than that. Thank you.
Thank you very much, Mr. Goedhart. So Yeah, as we can see, this is really a keen development in the Netherlands that we will all be following, and it's also its implications of outside the Netherlands, and especially what it could do at the European level. So our next speaker is FTA's own coordinator for France, Ms. Sylvie Tonnerier. She will present the recently adopted French corporate duty of vigilance law, which we already referred to quite a number of times, and its impact on companies, which is very important. This law has been welcomed already by many in Europe as setting a precedence in due diligence legislation. So it will be very interesting to see what Sylvie will be telling us. Sylvie, the floor is yours.
So, thank you very much. Can you hear me well? Okay, so thank you very much for this invitation to this very interesting webinar. And good morning and good afternoon, everybody. And I also will be happy to answer to your questions at the end of the presentation. So yes, let's talk about the French legal framework about due diligence and duty of care. First remark is that we do make a difference in France when we talk about due diligence, which we translate into a diligence raisonnable, and duty of care, which is for us devoir de vigilance. Let's say like duty of care would be the general obligation, the frame, and due diligence, diligence raisonnable would be the means. Well, shortly explain to you. Indeed, the path of this new law has been really chaotic because the first initial bill was proposed at the end of 2013 after the Rana Plaza dramatic event, and it was proposed by some deputies who had worked with NGOs and also scientists and people from the civil society. And finally, as you see, the final text has just been published at the Journal Officiel on the 20th of March of this year. The purpose of the French legislator, who was supported by the French government, by the way, was to increase the responsibility of transnational companies operating in the world and compelling them to identify, prevent and address adverse negative impacts of their activities on human rights, health and safety and environment in their supply chains. It's very important that to understand that the scope of application of this law is indeed very large, because it talks about, of course, the companies under direct control of the mother company, this is to say the daughter and sister companies, and also the companies in which two subcontractors and suppliers in the supply chain of the company with which the mother company has an established relationship, which is something which seems very vague, but is related to other parts of the French commercial law, in fact. So as you see, the sphere of influence is really quite wide, and it's part of the definition of the law. The law is indeed applicable to big companies, because we are talking about companies with headquarters in France and employing at least 5,000 employees internally and within their subsidiaries, or at least 10,000 employees internally or within their subsidiaries and with head offices abroad. As such, we can say that French subsidiaries of foreign groups, for instance, would be concerned by this French law, of course. So on the whole, it seems to be few companies concerned by this law, because we would talk about 150 to 2,000 companies, but at least these companies amount to about two-thirds of the total export of France. Next slide, please. So this new law, in fact, creates a new legal obligation, which is the obligation to write and effectively implement a vigilance plan in collaboration with stakeholders. The contents of this vigilance plan is already included in the law, which is a very short law, only with 4 to 5 articles, only one page, but everything is already in the text of the law. First, it's based on risk mapping, and we are talking about risk mapping in the entire supply chain regarding negative impacts on human rights, environment, and so on. And of course, when companies will have to deal with this risk mapping, that means it's not just the question and the responsibility of the lawyers inside the company, but it has to be worked, of course, with the purchase department and also the sales department everywhere. Risks can be for their negative, of course, is to identify those risks, to analyze them and to rank them, and then to put in place procedures and solutions that can, address these risks. The second point in the vigilance plan would be to put in place regular assessment procedures to evaluate the evolution of the risks, for instance. And of course, we are thinking here about a very important means of evaluation, which remains audits, either internal or external audits, but this would be still a very important tool to use in that to assess the risks. Of course, put in place risk mitigation actions, and also create inner alert mechanisms, and this will have to be studied and put in place in collaboration with worker unions. This is specified in the text of the law. And the final point would be to make a regular follow-up and evaluation of the efficiency of the vigilance plan. Actually, we are still waiting for an enforcement decree that would probably precise and give more details about the contents of the vigilance plan. What are the deadlines and sanctions which are foreseen in this new law? Well, there is a first obligation to publish the vigilance plan in the annual extra financial report. This is a report that is compulsory for bigger companies since 2012, and it's included in our trade code of commerce. So the vigilance plan will have to be included in this report, and this will start in January 2018, so you see very soon. And there is also a report on efficiency that has to be published just 1 year after, because as you have understood, the vigilance plans must be written, of course, but it must be efficient, and it must be evaluated as efficient all year long. The judge can send a formal notice to the company if nothing happens in the company. This is to say, if no vigilance plan has been set up, and the company will have, in case the company is still not compliant with this obligation of drawing up a vigilance plan, then an action could be launched either by the judge himself, or the law says by any person with a legitimate interest to act. And here we can think of shareholders, for instance. Margaret was talking about those new kind of investors that are asking the company management what they do about CSR obligations, for instance, so shareholders, but also, why not, consumer associations, and of course NGOs. So as you see, many people could ask the company to prove what it has done to prevent risks on human rights and environment. And the sanctions, of course, are not so heavy as the first draft had proposed, because we were talking about a civil fine of about 10 million euros at the beginning, which could be tripled. But at least the law implements civil responsibility for failure of having implemented an effective vigilance plan. And as such, the judge can sue the companies based on the civil case. And if there is a damage at the end of the supply chain, and if the victims, which will be very difficult for them, of course, are able to prove that the damage occurred because of either the total lack or non-implementation or non-efficient vigilance plan, well, then the responsibility of the company is engaged, and the judge will be able to pronounce any kind of a fine or condemnation. We can go to the next slide. When we are talking about impact on companies, from the very quick conversations I had recently with some French companies, of course, there is a direct impact on those larger companies that are directly concerned by the text. And the major impact is they are not starting from scratch, of course, those big companies, as they have this obligation of reporting about non-financial results. But of course, there is a trend from soft law to hard law. Now it's a legal obligation, and it's a very precise and demanding framework that is written by the lawyer, because companies will have really to be sure that the actions implemented are efficient and effective and efficient, and they are really they can really mitigate the risks, and it's here very important that the risk analysis be made really very thoroughly. And the other difference for those big companies is that they have now, although the text of the law is quite soft, but they have now to collaborate with their internal and external stakeholders, and namely with the worker representations, for instance, when we are talking about implementing the alert mechanism system. But the law also talks about collaboration in the framework of multi-stakeholders initiatives. So this would be also, even if not giving much details about this, we could think that maybe working within the frame of the FTA, for instance, would help bringing some frame and tools to the companies to build up their vigilance plans. And there is also an indirect impact on smaller companies, in fact, on all business partners of those big companies, and among those business partners there are many SMEs. So of course they are not directly concerned by the law because of the thresholds, but they are of course indirectly concerned, because those big clients of them would ask them for minimum requirements. What do, you supplier, to avoid the risks in your supply chain? Have you done your own risk mapping? Have you evaluated the situation using audits? Do you have some kind of KPIs in place and reporting and so on and so forth? So this is the end of the presentation of my side, and I'll be happy to answer all questions.
Perfect. Thank you very much, Sylvie. So now we will start off the Q&A session. So I'm sure that already we have so many questions coming in, but I will use my position as the moderator to ask the first question, because I'm really interested in it to all three of our panelists. I'm very interested on getting your insights on what are the implications of the development of the French law on due diligence on the wider EU corporate social responsibility environment. So as we have seen, it's one of the first due diligence legislation due diligence that has arisen in EU member states. And what do you think, how will this affect maybe other EU member states that are still not on the road to having CSR legislation, and on the European Union itself, since we know that the trade is a European Union competence, and many of these initiatives are closely linked to trade. So maybe first, Margaret, since you were our first speaker, and then Gilles and Sylvie.
Thank you. I mean, at an EU level, if we think formally about the response to the Green Card initiative, the Commission has said that it will not be adopting some kind of mandatory due diligence requirement. And as we know, the Commission is also, it appears, not going to be coming out with an updated corporate social responsibility plan. So in one side, quite formally, I think we have that response. On the other hand, we see there are numerous activities in the European Parliament on these issues. So I think the pressure will not go away, and I think the issue will become, in a sense, the way it pops up in other broader sustainability initiatives, whether it's on the financial sector side, where there is a lot of activity going on, or in other areas where there'll continue to be requirements around whether it's ESG or other kinds of due diligence. So I suspect we'll see it reinforced in other areas of EU law. And I think the French initiative on this will also provide an opportunity and an example to other legislators around Europe that it is possible, and it is now has been done to adopt legislation on this area. And so it will be very interesting to see. I don't know of other, outside the Swiss example that I gave, of other legislators that are more actively taking a broader sweep. But I think that is probably on the agenda in the next couple of years.
Thank you, Margaret. So we will go now to Gilles for his response.
I think I hope I'm audible. I agree with what Margaret said, basically. But I think that the French case has it may set off a trend, because I have a feeling, and this is just my personal assessment, having worked in this field for a few years now, that in a number of countries these ideas of adopting mandatory due diligence laws have been floating around for a while, but I think parliaments have often been skeptical or have been reluctant because it's never really been done before, and many legislators were a bit hesitant about what this might entail in practice. So I think probably the experiences with the French law will be very important to monitor and other countries might take an example, take a leaf out of France's book. The examples are starting to build up also with the Modern Slavery Act from the UK, which is a little bit different, but still has the same kind of background, and if the Dutch law is adopted as well, then that might increase pressure on the European Commission to start looking at some form of well, to see whether some form of action at the EU level may be desirable as well. I'll leave it at that. Sorry.
Thank you very much, Gilles, for your insights. Now, Sylvie, do you have anything to add?
I would just say that, of course, yes. Can you hear me? Can you hear me?
Yes, perfectly.
Okay. Well, I would just say that France has opened the way and shows the path. There is, as Margaret said, much movement, at least inside the European Parliament, with many groups inspired by this new duty of care law, French duty of care law. For instance, Spanish, Belgian, and also German deputies are really fighting to make the Commission change its mind. Of course, we will see maybe let's take appointment within 1 year and check what happened in 1 year. Have all of those big companies, we are talking about 150 companies, have they all drawn up this vigilance plan in the way the law asks to do? Has the judge been forced to interfere and to remind them their new responsibility? Well, let's check what happens in 1 year, and also what would be interesting to see is the way the European directive will be really translated into actions through national legislations, and in which way it will both laws will I mean complete themselves and improve the situation in that way.
Perfect. Thank you very much, Sylvie. Now, we have so many questions coming in. It's very hard to keep track of all of them. So we will try to gather as many of them and answer them afterwards. But let me now go quickly to one question from Ms. Larissa Dietrich. It's for Margaret. The question goes, is there specific human rights due diligence legislation in emerging markets, example India?
Thanks for that. Just quickly to go back to what Sylvie had just said, I think one of the drivers as well for this issue, exactly as she said, is kind of the evidence coming in on what companies are reporting they're doing under the non-financial reporting directive. And we know from a meeting we had earlier this week that the Commission is going to be looking at that evidence base. And I think if it shows that companies are taking a lot of action, that might mitigate some push. But on the other hand, I think if it shows that they're kind of very standard form responses with little connection to reality, which is a little bit the case we're getting under the UK Modern Slavery Act, that might prompt more action. So again, taking an evidence-based approach, and so I think it will be interesting to see what use is made of the non-financial reporting. As to India, again, there's probably quite a lot of, I'm not an expert in Indian law, but again, there will already be many things in Indian law, whether it's on environmental issues or consumer protection or corruption or other issues around these areas that are already in Indian law, and I couldn't begin to identify them all. I do know that the OECD has been working quite a bit with the Indian government in the hopes of having the Indian government ascribe to or become a party to the M&E guidelines, the guidelines on multinational enterprises, which still is not binding, but would again be a broader standard for Indian companies. So that's, I'm afraid, all I can say on that point in terms of the specific issues in India.
But also the question was, is there any in any other countries, so not only India, in other emerging markets? So I presume this would also include China and...
Yeah, I mean, again, you have in Indonesia, for example, very recently adopted, thinking back to that slide that I was talking about of focusing in on particularly severe abuse. There's a new Indian law on forced labor on fishing vessels. And I don't know if there's a similar one in Thailand, but I would assume, given the whole focus on forced labor in the Thai fishing industry. So again, I think you're getting responses to these different topical issues where you're getting specific legislation, and there is an increasing amount of activity at different country levels in emerging markets. I can say, because I do a lot of work on Myanmar, that Myanmar is probably one of the first countries in the world to have adopted into, for example, its investment law, a whole series of requirements, responsibilities on investors, both foreign and national, coming in around different areas of responsible business conduct. So again, you're starting to see it. It may not have that headline of human rights due diligence law, but the effect is the same. And so I think you're absolutely starting to see this weaving its way into a number of different countries' legislation in different ways. The OECD does a review of number of countries around the world, if people have ever seen those, and they usually have a whole chapter on responsible business conduct. So one area very quickly, a quick way, is to go see if OECD has done a country review and to look at those chapters. There's probably a number of other tools that people can use to identify those issues. But indeed, this is not just a European or North American. You're seeing increasing requirements expressed in different ways in many different markets.
Yep. Thank you. Thank you very much, Margaret. So I will now also compile a bit questions for next batches for Gilles regarding the Dutch law. And the first question is, from Jérôme Perrault, will the Dutch bill also cover tier 3 and 4? And the second question from Milis Kivsgaard is, how will the law affect companies exporting to the Dutch market?
Right, yeah, these are good questions, and I can only answer them partly because some of these issues, as I said, are still to be determined. As for the coverage, let me just see for a minute. Let me just pull up the text of the law. In principle, the companies that would be covered by the law are companies that that deliver goods or services to end users in the Netherlands. And as I said, companies could be exempted from that and probably will be on the basis of turnover. But in principle, that's quite a wide scope of companies, and it would include, for example, online retailers, and as soon as they deliver a good or service to the Netherlands or somebody in the Netherlands just once, that would mean they would be covered by the law in principle, unless they're exempted, as I mentioned earlier. As for the due diligence requirements and how far that would go in terms of the first, second, third, or fourth tier, that is still something that's to be decided, because as I mentioned, the requirements for the value chain assessment and for the action plan that the companies would have to adopt in response are still to be determined by the government in separate regulations.
Thank you, Hillis. So we have now two questions for Sylvie. First one is from Anne-Catherine Bilrup. Her question is the French law applicable for companies who may have customers in France but no office? And the second one, well, it's a bit of a technical question, and it's from Jérôme van Dijken. He asks, does the French law mainly focus more on transparency, obligatory vigilance plans, or on protecting the interests of parties in the supply chain by helping them enforce OECD guidelines?
Okay, so regarding the first question, the law is very clear. We are talking about companies having either their headquarters in France or having their headquarters in abroad, employing 10,000 employees and having activities but under the action of, if there is no office, no, I don't think that this kind of companies have to be, I mean, they are not concerned by the direct application of the law. They can only be concerned if they are suppliers of companies concerned by the law, and then they will have their customers asking them for what they do about the subject. Regarding the second question, can you repeat the question, please, Milan? Hello? I can't hear anything.
Yeah. Hello? Can you hear me now? Okay, so the questions asks, are the interests of parties in the supply chain covered by helping them enforce OECD guidelines? And is a third-party check on the vigilance plan required, similar to the financial reports, but not required by EU non-financial reporting?
I think I can answer to this question, but I would do this by written if it's possible. Mm-hmm. I don't have it.
Okay. Yeah. Yeah. Okay. This will be perfect. Yeah. A few on a technical basis. So we are really looking forward to having our 15th of June session on this topic of due diligence legislation across Europe. Clearly, we can see today with over 100 participants and so many questions coming in that the interest is extremely high. So we invite you all to come and attend this session where we can discuss this in more detail and a bit more time. But I'm sure we'll be talking about due diligence and human rights and corporate social responsibility for the coming days, years. So thank you very much to the panelists. It was really great to have your deep and thoughtful insights and expertise on this topic. You have really proven that you are clear experts on all these issues. We will be following up with an email on many of the questions that we didn't manage to answer today. And yeah, the only thing I can do is thank you for your attention. And if you're really interested in more of our services of the FTA and what we do and the news, that what we are up to date, stay with us on our website. And for any other information, you can contact us on the email link you can see on the screen now. And yeah, thank you very much for tuning in, and until next time. Hello. I'm just talking to the panelists now. Sylvie, you are still there,
Yes,
I see.
I'm there, yes.